Welcome back to Good Law, Bad Law. Can a horse named Justice seek justice in court? That's the question Matthew Liebman is asking and demanding a yes answer from an appeals court in Oregon. And he is my guest on today's episode of Good Law, Bad Law, a new professor of law at the University of San Francisco, School of Law in San Francisco, and a veteran of the Animal Legal Defense Fund, pursuing his compassion for animals that he's had since he was a child, now as a lawyer and now as a law professor, and now on behalf of a horse named Justice. You won't want to miss this. It is such a pleasant and, as always, fascinating conversation, but a pleasant departure from the chaos of the world around us. I think it's even better than a cute puppy video on Twitter or Facebook, and I know you'll learn a lot, as I have. So please stay tuned for this episode, and as I've taken to saying in recent weeks, everybody please continue to take COVID precautions. The virus is still out there. The flu season is upon us. Please stay safe and healthy and protect yourself and your loved ones. And where you can vote in person now, please do. Everybody engaged in the process. It's a vitally important election. If you can vote by mail, get your ballots filled out properly and sent in a timely way. And if you're going to vote on November 3rd, make sure you get there and vote. It's so important. And I wish us all well in this election. Stay tuned now for a great episode with Matthew Liebman on animal law. I want to welcome my guest today, Matthew Liebman. Matthew is a new professor this year at the University of San Francisco Law School in San Francisco, teaching and really specializing in the field of animal law. So Matthew, first of all, welcome and thanks so much for being on the program.
Thank you so much. It's my pleasure to be here.
I have to say, we've been doing the podcast now for, I think, about 3 years, and I have been wanting to do an episode on animal law, I think from the very beginning. So I'm really especially excited to have you on and talk about this subject. And it's also a nice departure, I think, from the chaotic, crazy politics that we're in the middle of, that it's so hard to avoid filling the space between your ears every waking moment. So I think this is a relief, actually, of the kind, that we can talk about something as interesting and different and also important as the subject. So welcome. And as I like to do, maybe you could start off and tell us a little bit about yourself and how you got into this topic as an area of concentration. And then I want to talk about what are some of the areas of animal law that you've had experience with.
Sure. So I am, as you mentioned, a new professor at the University of San Francisco School of Law. I'm heading up a new program called the Justice for Animals program there, which is a transition. For me, I was a practicing litigator for about 12 years at an organization called the Animal Legal Defense Fund, where I did animal protection litigation as a litigator, and then became the director of the litigation program there, where I led a team of about a dozen lawyers doing really important, groundbreaking animal protection litigation and all aspects of animal use and abuse. So I made the transition from practice to academia. Before that, I was a clerk for Warren Ferguson of the Ninth Circuit and law school before that. So I came directly into the animal law movement from law school. And in fact, my interest in animals far predates my interest in law. For me, law was a means to an end, and that end being to protect animals. I've been interested in animal rights from a pretty young age. I always had a compassion for animals and became vegetarian in high school. I had adopted a little parrot, a bird, and had this epiphany when I was about 15 of the similarities between his leg and the drumstick of a chicken. And I sort of had that realization that the meat that we eat actually comes from real animals and ones that aren't all that different from the companion who was sitting on my shoulder. So for me, that was my introduction into thinking about animal issues. I went to the University of Texas and majored in philosophy, wrote my undergraduate thesis on animal ethics, and started to sort of systematize a lot of the intuitions I already had. And so from there, I was asking the question of how could I do the most to benefit animals, and decided I could probably do more with a law degree. So I went on to law school and focused on animal rights law, and then went into practice, and now have moved into academia.
Well, and if you hear a squeaking sound in the background here, that's my own animal. I have a 5-month-old Bo, and he's discovered. I tried to get him a squirrel toy because when I take him out, he's chasing every squirrel in the area, and unfortunately has a little squeak. So I think he'll be quiet. You'll be quiet. So you got interested in animal rights really through vegetarianism. How did you make the connection between your interest and compassion for animals and law as a way to work to advance animal welfare?
Well, I think, as an undergraduate, I was studying philosophy. So I was interested in the philosophical questions of what our obligations to animals are, and was learning in doing so what the gaps were between what I thought they were owed as a matter of ethics and morality and the ways that we actually treated them in practice. And so my concern was figuring out how to change the practical reality to match what I thought the ethics demanded of us. And so I was thinking through how best to do that. And certainly there are many routes. One could be, an activist giving speeches or handing out leaflets. One could be creating great works of art that inspire people to compassion, or one could be a lawyer, which sort of is in a lot of ways I've learned kind of being a philosopher in practice. And so for me, just kind of thinking about what my personal skill set was, what I felt like I was good at, reading and writing and research and coming up with arguments. I was a debater in college as well. Law seemed to be like a pretty good fit. So I went to law school from there and decided to focus on how do we create laws and systems and rules that can put into practice the ethics that I hold personally and that I think my philosophical studies led me to believe are what we owe animals.
And you mentioned the Animal Legal Defense Fund, and that's where you worked before you took this job in teaching. What are some of the kinds of cases or the kind of work that group was involved with?
So that's an organization founded by one of my mentors, Joyce Tischler, who founded the organization in 1979 to sort of, she had also gone to law school before there was an animal law movement, and had read Peter Singer's Animal Liberation and was inspired to sort of, I think she was someone who came to law before animals, but then tried to synthesize the two. And so the organization has a pretty long and storied history, but the kind of work that it's done historically and that I worked on really ran the gamut in terms of areas of animal use and exploitation. And animal law really does touch on almost every aspect of modern American law, which is not surprising because animals touch on almost every aspect of modern American life, right? They're from the cows and chickens and pigs who we eat by the billions, to the rabbits and mice and rats who we test our cosmetics on, to the dogs and cats and birds who we share our homes with. Animals are everywhere. And so the legal system touches on them in so many disparate ways. So there were cases concerning companion animals, both in terms of fighting their industrial exploitation at puppy mills, but also cases involving how do you compensate someone when their companion animal is killed. Under the legal system, animals are considered property. So do you just compensate someone the same way you would any other property? Is it just the market value of an animal? That doesn't seem fair if we have these relationships with animals that far exceed their property value. So, there are companion animal issues. We did a lot of litigation concerning farmed animals who are among the most severely exploited and abused animals in the highest volumes, literally billions and billions of animals. We did cases concerning captive wildlife, wild animals in the wild as well. So the Animal Legal Defense Fund does a wide range of litigation to protect animals. And that's what we worked on when I was the director of litigation there.
Now, we're going to get into a particular case, I know, in a few minutes that really kind of bends the mind in thinking about who has the right to bring a lawsuit, who has a right to bring a rights case. I mean, normally you think of civil rights and the civil rights movement, or the women's rights movement, or the fight for same-sex marriage in this country, and all of those battles that continue to be fought every day in courts. Voting rights are people who bring claims in court when either they've been injured or they're trying to make progress on some aspect of that right. When in some of these cases at the Animal Legal Defense Fund, does the organization bring cases, or are you looking for people who are bringing cases on behalf of either a wild animal or a farmed animal or a domestic, a pet?
Yeah, I mean, so for the most part, this is what we lawyers call legal standing, the question of who has the ability to file a lawsuit. And notwithstanding the case we can discuss in a minute, that has always been human beings. It has been humans who are injured. And so the animal rights movement's use of litigation as a tool to remedy the suffering of animals has had to fit into those pre-existing categories that the legal system has established, even if they are anthropocentric or speciesist or human-centered. So a lot of the cases, do have to do with finding how is this abuse of animals harming humans, and how can we represent humans to file lawsuits to stop that abuse. And so a lot of our puppy mill cases, for example, were representing people who had purchased dogs from puppy mills, which of course we wouldn't endorse, but they had bought animals from pet stores that had gotten those animals from puppy mills, and then their animals had gotten parvo or some other sickness. And so we had to sort of file cases on their behalf for the property injury they suffered. So a lot of the animal protection litigation does have to frame itself as an issue of human protection, even though the ultimate relief that we're seeking is to benefit the non-human animals who are victimized by these industries.
Well, that's what I would have thought, and that takes us to the case of Justice the Horse, which I'm really so curious to learn more about, because as you said earlier, really the only thing I can think of that I learned in law school about what remotely could be called animal law, and I don't remember the name of the case, but we learned that the death of an animal, and it might have been a horse actually, a thoroughbred, a racing horse, under the law is treated as property and not really as a life or as a creature that a human being has an actual relationship with. It's just property. It's what's the value of that horse. It happened in that case, I believe that value was a lot because this was a racehorse who had the ability to be hired out at high prices to, create other racing horses. But now with this Justice the Horse case, which I want you to tell us about, you're really taking a leap into a whole new way of thinking about advocating for animal welfare.
That's right, yeah. And to go back to your point about animals being property, I think the first case I read in my property class as a first-year law student was this case Pearson versus Post, which is about who owns this dead fox. So there's this fox who's minding his own business, running through the woods. Two guys are trying to hunt the fox. One of them is in hot pursuit. The other one swoops in at the last minute and kills the fox. And the question is, who owns the fox? And of course, the answer is never the fox himself. It's, you know, the person who killed the animal rather than the person who's in hot pursuit is the one who owns the animal. But, you know, this sort of, to me, represents how fundamentally the legal system from the beginning, the property paradigm for animals is taken as a given and not questioned. But yeah, this is a case that doesn't directly challenge animals' property status, but asks the question of whether, despite the fact that they are property, do they have legal rights and can they be legal subjects?
And can they actually, can an animal actually bring a lawsuit?
So that's the question. And you know, there's really sort of two primary projects of the animal law movement. One is kind of what I already discussed, which is how do we use the legal system to fight the suffering of animals? What can we do with this toolbox that we have to stop industrial exploitation of animals at factory farms, at puppy mills, at roadside zoos, at circuses, et cetera. But the other half is a more kind of fundamental philosophical shift that the movement is after, which is not just how do we protect them from suffering, but how do we change their legal identity in a way that recognizes them as the kinds of beings that they are, which is sentient beings with their own desires and wishes, with the capacity for pleasure and pain. And if that's who animals are, to relegate them to the status of property is a fundamental injustice in the legal system. And how can we use our tools as lawyers to transform animals' status as things and put them into the category of legal persons who have rights rather than simply being inanimate objects, being things who are the rights of others, who are the property of others. And so there have been a few different approaches to this issue, one of which is a project by a group called the Non-Human Rights Project and a lawyer named Stephen Wise to try to get writs of habeas corpus for chimpanzees and elephants. Another example is litigation by People for the Ethical Treatment of Animals, or PETA, to have orcas at SeaWorld declared enslaved under the 13th Amendment, or to win copyright protections for a monkey who took a selfie under the Copyright Act. None of those cases have succeeded. We have our own case that the Animal Legal Defense Fund filed and that I was and am the lead counsel on, which is Justice versus Vercher. And this is a case that seeks to establish the right of non-human animals to sue their abusers when they've been victims of animal cruelty, to sue them for damages in civil court. And what this case seeks to argue is that animals, by virtue of receiving the protections of the anti-cruelty laws, are rights holders. They've been conferred rights by our legislatures, and those rights include the right not to be treated cruelly. And when those rights are violated, they ought to have recourse to the courts for compensation for the damages they suffer when those rights are violated. And that's analogous to rights that human plaintiffs have. A human who is...
Yeah, where somebody is part of a protected group by some statute. And if you're in that group that the law is intended to protect or benefit, then you can bring a case to advance those claims and those rights.
Yeah, that's exactly right. And in, you know, a human who's the victim of a crime, the person who perpetrates that crime might be criminally prosecuted, but the individual who is the victim has their own civil cause of action against the perpetrator to recover any damages they sustained. And so in the same sense that a victim of an assault might have a civil case for their medical bills, we argue that Justice the horse, and I can say a little bit about his factual background, he should have the ability to recover against his owner for the veterinary bills that, the veterinary treatment that will be necessary to bring him back to health. Justice was severely neglected. He is a horse who was confined in a field in Oregon, and his owner just decided to stop feeding him in the dead of winter. And he received essentially no food, no water, no veterinary treatment. and ultimately got penile frostbite from being left out in the Oregon winter. He was 300 pounds underweight when he was rescued. And as a result of all of that, will need lifelong veterinary treatment, both physically, but also socially and emotionally, to bring him back to the status that he was before he was subjected to cruelty. And that those injuries are going to take money. And who should pay for it? Well, not the rescue that stepped out to rescue him. Of course, justice can't pay himself. It should be the defendant. And that's the basic principle of the tort system, is that the person who did the wrong should be the one to make it right monetarily. So that's what this case is seeking.
Now, so is this case in Oregon then? Is this case in state court, in federal court?
Yeah, it's a state law claim in state court in Oregon. It was filed as a negligence per se action. And for the non-lawyers, negligence per se is just the idea that where the legislature has created a duty through a statute, like the animal cruelty laws, where it set the standard of care that one person needs to exercise towards another person, the breach of that duty or the violation of that statute can be the basis for a negligence tort. So in the same way that someone who illegally runs a red light is liable for the damages they cause from that, someone who violates the anti-cruelty law should be liable for the economic damages that come from that.
So what is the defense position? I mean, this owner is the challenge. Is there a challenge to Justice the horse being able to bring such a claim, or who should be the right to? Who is Justice the horse bringing this claim in his own name?
He is, yeah. The caption of the case is Justice versus Vercher. He is the plaintiff. There is a guardian. There's a woman named Kim Mosman who runs an organization called Sound Equine Options, which is the rescue sanctuary organization that took in Justice and has nursed him back to health and has custody of him. So she is sort of acting in a guardianship position where we actually have a representation agreement with Justice through Kim as his guardian, where she agrees to take action only with the standard being what's in his best interests. So she is contractually and from a legal ethics perspective obligated to behave in this case in a way that optimizes Justice's interest. But he is the client in the same way that if a child were injured, the child would be the plaintiff, but they would need someone with the capacity to actually participate in the litigation.
Right, and a guardianship is a very common way that's done, or a parent as guardian. I mean, that happens all the time. Parents bring cases on behalf of their children who can't legally make the decision, I want to sue over that.
Right.
That surgery that went bad or whatever it might be. So that part seems well grounded in at least the analogy of a guardian, say, to a child, that there could be a guardian of an animal, here a horse. So what is the position of the defendant then? Because that part sounds reasonably sound to me.
Yeah, I mean, the argument is that, come on, Your Honor, this is a horse, in essence. And the trial court agreed. The case was dismissed at the trial court level. It's currently on appeal. I just argued the appeal, the oral argument, at the beginning of September. So we're waiting on a decision from the Court of Appeals on whether they agree with the dismissal of the case. But the position of the defendant and the position of the trial court judge was that there's simply no precedent for having an animal be a plaintiff in a lawsuit, that the legal system is reserved for disputes between human beings. There are a few other arguments as well. The animals lack the capacity to have legal responsibilities, so they can't have legal rights, that those two concepts go hand in hand. And so without being, if Justice can't be criminally liable if he, kicks a kid, or can't be civilly liable if he causes damage, then he doesn't have the reciprocal right to be a litigant in those cases. Our answer to that is that that's not the case in human context either, right? Like children might be, they have rights against being treated in ways that are cruel, and they are entitled to damages when they're injured civilly, even if they're don't have the age of majority that makes them liable for crimes. So, but there's a lot of sort of, this has never been done before, and as a threshold matter, animals simply don't fall into the category of who can be a litigant.
Well, I'm curious what the attitude of the judge was. Obviously, I mean, you've said the case was dismissed, but is there, and often trial judges have to defer to what the law says. They're trying facts and then having those facts applied to law as it is. You very rarely see a trial judge looking to make law. Law gets made more often at the appellate level anyway, in the appeals court. So, but I'm curious what the attitude of the trial judge was. Was this just, oh God, this crazy case landed in my courtroom? Or was it, these are some very interesting philosophical arguments about what the law is. And, you know, maybe this is something I don't feel I have the authority to do, but I find this pretty darn interesting. I mean, what was the judge like?
He was much more on the latter. He was, you know, I think if you're a trial court judge and most of what you're seeing is, you know, tedious discovery disputes or, you know, so-and-so owes me money, and you get a case about whether a horse can be a plaintiff, you know, that's probably refreshing. So he was great. I mean, I wish he had ruled the other way, but he was definitely open, held a hearing, and allowed press to come in with cameras and record the proceedings. I think was very interested in giving it a fair airing, and then rendering his decision. And I found the same with the Court of Appeals, that the panel was not sort of like, you know, what is this? How dare you waste our time with this? They were very interested in the fundamental philosophical questions. They pushed back, you know, a lot of the defense argument was animals can't participate in the social contract. They don't have language. They can't communicate. There's no way they could be plaintiffs. And the court really engaged in that deep philosophical conversation about, well, you know, we have humans who can't do any of that, and yet we extend legal rights to them. So what's the essence of being a rights holder who has the capacity to sue in a court of law? So I've been impressed with the judges throughout this case that, you know, and I think it's an indication of how far animal law has come, that judges actually take these questions seriously, even if so far they're not ruling in a way that goes in favor of the animals. And anecdotally, from the Non-Human Rights Project cases, I think most of the judges there have taken those cases quite seriously, but as you say, feel constrained as trial court judges to not rock the boat too much.
You know, it's not that surprising, but then there are analogies to other areas of rights law in the way the law develops, where in the beginning, a judge or anyone listening to the story might say, oh, come on, that's never going to get anywhere. And you do have to lose so many times before you can start winning. I mean, that's been true, I think, of every rights movement we've known. I'm curious too, because obviously your philosophy background serves you well here, where you have to do more than just say, oh, you say they're property. No, they're not. I mean, you really have to dig deeper to the fundamentals of what the law is and understand parallels, seems particularly to situations where children, young children especially, have rights, even where they don't have responsibilities in the same way. I'm just curious, there is the Pearson versus Post case, which is an old case. Sometimes you do go back deep into the early foundations of law, even back to English law, to find kernels of what becomes a building block, which becomes, an argument that ultimately has some momentum behind it. Are there any nuggets deep in the dusty books of English law or early American law that you can build on, or is it all fox hunting and any animal is property, period? That's the end of the story.
Yeah, I mean, the history of animals in the law is mostly one of domination and exploitation. But the virtue of this claim is that it is a common law claim, and the common law evolves. Yeah. So, the limitation of some of the other cases, the Copyright Act case, the 13th Amendment case, even the habeas cases, is that they're a bit hemmed in by a statutory framework. And when you're interpreting a statute, the question is, what did Congress intend, or what did Congress intend? So those claims get locked into history in ways that a common law claim doesn't necessarily. The common law, and there's great Oregon precedent, sort of judges waxing poetic about the power of the common law to be responsive to changing social mores, and to understand that where a rule no longer serves the principles of the law, that it ought to be changed. And Stephen Wise has written a lot about this adaptability of the common law. And his habeas corpus cases are technically common law cases, but they're reliant on statutes in ways that have kind of hemmed his success in. But judges sitting in common law, which a negligence tort is a common law claim, have the ability to say, well, this rule that we've had forever no longer makes sense based on what we know about who animals are, what we know about what evolving ethics demand of us, and the way that the legal system has evolved over the last 200, 300, 400 years, 2,000 years for that matter. And they have the authority, if not always the will to exercise that authority, to say the rule should be other than it has been. Now, one of the limitations with regard to property in particular is that is statutorily codified in most states. There are statutes that say animals are property, and the courts can't rewrite those. So what we're arguing in this case is not that animals are not property, but that property and personhood is a continuum, and that one can be both property and person at the same time. And in fact, corporations have that status where they can be bought and sold, but they also have constitutional rights, as we know from Citizens United and other cases as well. So if corporations can be property and person, then animals' status as property shouldn't disqualify them from being considered persons who have the authority to sue, even if the scope of their rights might be limited.
I think that's great. And it always baffles me when, particularly, well, this is a week where a former Federalist Society legal thinker, law professor, judge is going through confirmation hearings to get onto the Supreme Court. And this idea that judges don't make law, we just have to look for the original meaning. I mean, judges make law all the time. That is what the common law is. It's judge-made law. It's a very important part of our law altogether. And so it's fascinating that you can use that and continue to press these issues till perhaps bit by bit. Is that part of the strategy, is that brick by brick you're raising awareness, and over time you look for some victory that gives you a foothold or a hoofhold, into something that then you can build on in the next case.
Yeah, that's exactly right. I mean, I consider what we were doing at the Animal Legal Defense Fund to be strategic impact litigation on the model that the NAACP pioneered in the 20th century, the 19th and 20th century, to develop incrementally a jurisprudence that leads towards a goal. And I don't mean to make an express analogy, but I think tactically the idea is similar, that you sort of pick small cases that can build on themselves and on each other, and that track developments in society. I mean, I think there is a dynamic relationship between public opinion and the law. And the law doesn't merely follow public opinion, but it also doesn't dictate public opinion. And it's sort of a back and forth dialogical conversation that happens. And, if on the one hand, we're doing these sort of cases that raise public awareness about how awful animal abuse is, and we're also doing cases that are raising public awareness about why animals ought to be entitled to legal personhood, and we're also creating documentaries that shed light on how bad SeaWorld is. All of this stuff sort of synthesizes over decades in a way that transforms popular culture and therefore has the potential to transform legal culture.
So now you mentioned as part of your work at USF, there's going to be an animal law clinic. Is that right?
Yeah, it's on the table. So we're not committed to that. The program just started this year. And so right now the focus is on creating interest among the student body, drawing in students that are interested in animal law. But absolutely, if once the interest is there, to create an animal law clinic would be fantastic.
Well, and I should maybe this is the time I should disclose. My sister Susan is the dean of the law school there, and she's actually the one who suggested you'd be great to talk to about this, and she was right. I think if you send me the brief that you just submitted in the appeal on the Justice the Horse case, I'd like to, or if there's a link to it, I'd love to post a link to that in the description for this episode, because I'll bet it's a great read. And if people want to learn more, I imagine that you're going to get a whole introduction to the law in this area through this case. If you read that brief, I would think it's a pretty good read.
Yeah, it was, my colleague, Chris Berry, did most of the drafting on that, and we worked together, and he's a fantastic lawyer. It was a very fun brief to write, because, a lot of our work is, the more mundane stuff, but to really kind of get to the heart of the issue was nice.
Well, it's a great story. As I said, I've been really wanting to learn more about this subject as long as I've been doing this, and every week when I do this podcast I get to learn something new, and I think this is something people need, like they need cute kitty videos on their Twitter or Facebook feeds in these times. So I think it's great. It's great that you're at USF. I wish you the best of luck on the appeal, and again, if you send me a link to it, we'll put it in the description, and we'll put a link to the Animal Legal Defense Fund as well. I imagine there's a website people can go to and find out more about the work you're doing at that group as well.
Yeah, and we can also include a link to the USF Justice for Animals program as well. I'm excited to get that launched and really sort of bring interest in animal law to campus. I'm already teaching an animal law class now, some really engaged students, and another seminar next semester. So as we continue to build out the curriculum and add a clinic, it'll be a fantastic place for people who are interested in animal law.
So cool. Well, I want to thank you again, Matthew Liebman at the University of San Francisco School of Law. I think I said it wrong the first time, who's a new professor this year teaching animal law and working on behalf of Justice the Horse and animal rights and animal welfare more broadly. Really great to meet you and great to talk with you. Thank you so much for being on Good Law, Bad Law.
It was a pleasure. Thanks for the great conversation.